Welcome to Animals in Community Associations 2024. It's June 18th. My name is Scott Carpenter from the Carpenter Law Firm, and I am thrilled to present this today for community associations in Arizona. Well, the legislature adjourned on June 15th, 2024, last Saturday, and this is the opportunity for us to consider, what did the legislature do this year? What's the extent of the damage, the regulation, if you will? The governor signed 9 bills that impact community associations in 2024. This is not the record, but it's more than a few. And you may recall that in 2023, the legislature enacted a parking regulation, a parking statute that requires all planned communities to vote on whether or not to keep a covenant, a CC&R provision regarding regulation of public roadways. And this vote has to occur before June 30th, 2025. Some of you may have already done this, and we have until June 30th, 2025, which is 12 months and a few days away. There's plenty of time to get this done. It can coincide with an annual meeting. You may have already done it, but if you haven't, we have to consider whether or not the association desires to continue to regulate a public roadway. Now, many people assume that this has to do with parking of vehicles. We'll remind ourselves when we do the legislative update for 2024, when we review this bill from last year, that the word vehicle and the word parking did not appear in last year's statute or bill, which is now part of the statutes. We're going to talk again at our legislative update about the Corporate Transparency Act, a federal statute that requires all nonprofit corporations to register with the federal government by December 31st, 2024. We still have 6 months, but we have to remind ourselves of that. All 9 of these bills have an effective date of September 14th, 2024. That's a Saturday. And our legislative update seminar in this webinar format will be July 16th, 2024. Bring your own lunch. Eat and drink whatever you want, watch it in your pajamas or whatever you want to, and we'll be doing that on July 16th, as has been our habit. We're doing these on Tuesdays each month, July 16th, so that's coming right up. So let's talk about animals. I want to start with the criminal code. Here at the Carpenter Law Firm, we are not criminal lawyers. I wanted to start with a review of the. Did I have my video off? I apologize. Don't know how that happened. I want to start with the crimes, and I want to start with dogs because often when we talk about animals in community associations, we talk about dogs, and we'll start with how we deal with dogs in community associations. So let's talk with vicious animals and how owners can have their some liability. The statute is Arizona Revised Statutes, section 13-1208. A person in Arizona who intentionally or knowingly causes any dog to bite and inflict serious physical injury on a human being or otherwise cause serious physical injury to a human being is guilty of a Class 3 felony. Unless the person would be justified in using physical force or deadly physical force in self-defense or defense of a third person, pursuant to Chapter 4 of this title. Here's where it gets interesting. A person who owns a dog that the owner knows or has reason to know has a history of biting or a propensity to cause injury to others, or has been found to be a vicious animal, is guilty of a Class 5 felony. So if you know your dog's a biting dog, then it's Class 5 felony. So the same thing's true here under subsection C of the statute. Basically, if you have a vicious animal, then you're in trouble under the criminal code. Doesn't apply to dogs that are used by law enforcement or that are used in the performance of police work. And one of the things that's missing here from the criminal code is the idea of a vicious breed. Basically, it has to do with specific animals. And so we often hear in the community association work that certain breeds are vicious. And defenders of alleged vicious breeds say that's not true, that any dog can be trained to be calm or domesticated. And the statute does not feed into the notion that there are vicious breeds of dogs. And the statute really backs up the notion that it's dog specific and not breed specific. The legislature has not said this particular breed is a vicious breed. The legislature has essentially said it's dog specific. It's not breed specific. There's also a statewide statute that says dogs are not permitted to roam at large. And I found this interesting. I haven't spent a lot of time in this in my practice over the years. Neither a female dog during her breeding or mating season, nor a vicious dog shall be permitted at large. Essentially, your dog cannot roam about the neighborhood. And a vicious dog cannot be allowed to roam at large, nor a female dog during her breeding or mating season. It's one of the reasons why Bob Barker used to say, get your pet spayed or neutered. A female dog during her breeding or mating season cannot be permitted at large. I'm a dog person. I have 2 male dogs in my household. And so this wouldn't be a concern, I suppose, but solved by, and I don't remember which is which, whether a female dog is spayed or neutered. Maybe neutered is the word for the female, but and I probably just got that wrong. Either way, the female dog is not allowed to be roaming about while she's breedable, I guess is the word, or mateable. And so it's a crime to permit your female dog to be out and about at large. And in a rabies quarantine area, which doesn't seem to me that happens very often, no dog shall be permitted at large. And each dog shall be confined with an enclosure on the owner's property, secured so that the dog is confined entirely to the owner's property, or on a leash not to exceed 6 feet in length and directly under the owner's control when not on the owner's property. And then subsection C, this is interesting because until I started working on this presentation, I was under the impression, and you may have been too, that leash laws here in Arizona were entirely municipally driven, that essentially leash laws were from city ordinances, and they are. That if you're in the park or on the street in Phoenix, for example, the leash law is a Phoenix ordinance. Or if you're in Gilbert, the leash law is a Gilbert ordinance. But in fact, the leash law is also an Arizona state statute. So here it is, subsection C. Any dog over the age of 3 months running at large shall wear a collar or harness to which is attached a valid license tag. So we have to be identifiable, and that's good. And subsection D, that was the license portion. Subsection D is the leash law. No person in charge of any dog shall permit such dog in a public park or upon any public school property unless the dog is physically restrained by a leash. And this is actually sort of interesting to me A number of years ago, I used to run on the canals a good bit. And there were times before my dog became a dog family that people would walk their dogs on the canals without a leash. And it kind of bothered me. Every once in a while, people would, a dog would run up at me while I was running along. And it bothered me a good bit because I didn't know what the dog was going to do. And people would say to themselves, sometimes I could tell, oh, he's harmless. Well, I don't know that. I don't know that as a runner. I don't know that as a pedestrian. I don't know that while I'm pushing my kid along in their stroller. I don't know anything about your dog. And I found it somewhat arrogant and presumptuous for dog people to be walking their dog along the canal without a leash and assume because they know their dog and they believe that their dog is harmless, that someone walking along or running along the canal would find it enjoyable or funny or recreational for their friendly dog to run up to them and lick their ankles or smell them. And I did not appreciate it. Now, as I said, I'm a dog person, two great dogs in my household. And even as a dog person, I remember vividly not appreciating one bit an off-leash dog running up at me. And I never kicked the dogs that came running up at me, although I imagined it. Because I did not appreciate it one bit. And I also did not appreciate the dog lover thinking, oh, they're friendly. No, they're not. That's not how I felt. And I was not appreciative of the fact that they were so presumptuous about not having the dog on a leash. All right, let's talk about feeding of wildlife. There is a statute about the crime of feeding wildlife. It is unlawful to feed wildlife. And the crime is unlawful feeding of wildlife by intentionally, knowingly, or recklessly feeding, attracting, or otherwise enticing wildlife into an area, except it is okay for persons lawfully taking or holding wildlife pursuant to rules and orders of Arizona Game and Fish Commission. It is acceptable for public employees acting within the scope of their authority for public safety. It is acceptable for normal agricultural or livestock operations and practices. And it is okay to attract tree squirrels or birds. Now, I've had a number of cases over the years where someone, and in fact, I remember a case quite vividly where a woman, and let's concede there were mental health issues going on here. She would sit in her backyard. She backed up to a small lake in an East Valley community. And she would sit in her backyard and excessively attract birds with some kind of grain or other food attractant. And she attracted so many birds that her rear yard was white from the excrement, not from white granite rocks, but white from the excrement. The noise and the smell of the excrement was overwhelming to the neighbors. And of course, the neighbors wanted the association to do something, solve the problem. And it was an overwhelming situation for the association. And they asked me to help and figure out what can we do about this? Is there a violation in the CC&Rs that we can find? And of course, one of the things that we as lawyers do is we go through the CC&Rs and find how is that a violation? And is it an offensive activity? Is it a nuisance? Is she attracting a nuisance? Is it a violation of a state statute where we have that provision in the CC&Rs that says any violation of a state, local, or federal law is a violation of the CC&Rs? That provision is always helpful when we have it, but that conduct would technically not be a violation of a state law. Is it a violation of federal law? Probably not. I mean, we could comb through federal law. Ordinance of the town of Gilbert, perhaps, we'd have to really think that through. More of a nuisance or an offensive activity, given the smell that she's creating. But under state law, what she was doing is not unlawful to feed birds or tree squirrels on your property. So it was a little bit of a strange one. It's not unlawful to feed birds. And one of the things that we deal with every once in a while is feral cats. I'm not sure that I would consider feral cats to be wildlife. We're talking here about attracting wildlife in terms of deer in certain parts of the state, or other wild cats, or coyotes, or something wilder than feral cats, which may have started out as domesticated, got out and started feeding on whatever was out there. This section really only applies to counties with 280,000 people. I double checked today. Maricopa County, Pima County, and Pinal County are the only 3 counties in the state that have more than 280,000 people. Yavapai County has less than 280,000, and Mojave County comes in next below that as the 5th biggest county. You might be surprised by that, but Maricopa County is the biggest. Obviously, Pima County comes in next, and Pinal County is the 3rd biggest county. 15 counties in the state, those are the 3 biggest, and it only applies to those 3. You can't feed wildlife unlawfully, knowingly, recklessly, intentionally feeding, attracting, or otherwise enticing wildlife into an area, except those for those 2 types of people, and tree squirrels or birds, or normal agricultural or livestock operational practices. It's a petty offense. It's not actually that big a deal. You're not going to get in that much trouble. But we don't want people enticing wild animals into the community. So if crimes are committed, we need to call the police. We need to know the statutes and call the police. And leash laws are tricky, but in general, it's difficult, especially when some of the leash law violations that I've seen, both in living in the East Valley and dealing with community associations that I have for over the years, is that often when people walk their dogs off leash, it's a very old dog that lumbers along, and people think, oh, this is silly. He or she is old, half blind, stands right next to me, and the dog is not going to be chasing after anybody. It's not going to bite anybody. It's old Sally. There's nothing that's going to happen. So what's the problem? Being on a leash would just be silly. The dog reacts to my voice, not going to go anywhere. Why should we call the police? Well, people are going to complain about anything. It is the law. And if the dog is that old and is not going to go anywhere, it wouldn't be that big a problem to have a slack leash on the dog just to comply with the law. And I'm a little surprised at how many people want to be defiant about it. We should call the police and let it be their problem. And as I mentioned, the leash law is a state ordinance. It can be enforced by sheriffs, police departments, and any other law enforcement agencies. When we're dealing with feral animals, it's not against the law in Arizona. We also want to be sure that we don't attract and create animal dependency. And attracting law enforcement to the problem of feral cats is unlikely. there is this notion of being inhumane to trap and kill feral cats. There is a statute called ARS 132910, cruelty to animals. It is a crime to commit cruelty to animals if the person does any of the following: intentionally or knowingly subjects any animal to cruel mistreatment. When we hire companies that deal with trapping animals, whether it's pigeons or other vermin, they have to comply with this statute. And so whenever the professionals are called in, pest elimination companies, they're sensitive to this statute. They're professionals. And so when association boards sometimes say, well, I'm just going to go take care of the problem, I'm a little concerned because I don't know what they're doing. I don't know what poisons they're using and what trapping systems they're using. And, sometimes, board member Bob says, well, I'm just going to go take care of the problem. Well, they could be committing crimes. And, when someone in the community is feeding feral cats and causing a problem, and then everybody gets upset that there's 50 feral cats in the community, and someone on the board says, well, I'm just going to take care of the problem. We could have the association party to crimes under the cruelty to animals statute. We want to be careful about that. So we've got those concerns under the cruelty to animals statute. And feral cats, of course, are tend to be somewhat problematic. One of the things I've learned recently from a friend of mine is that the feral cat feeding community actually is one. They've got a system where they will place food in the middle of the night for feral cats, and they'll place it sometimes in the drainage culverts. And you're going to be walking along at night, and if you shine a flashlight or your phone's flashlight into drainage culverts, and you look down, you might be surprised that there's food in the culvert. And you say, well, how'd that get there? Well, it's placed there intentionally to feed the feral cats. Like, who put it there? Well, somebody who's dedicated to feeding the animals. Well, we don't need to feed these animals. They will survive without being fed, just like the wildlife. The Arizona Game and Fish Division, on their website, in discussing the unlawful feeding of wildlife statute, says they don't need to be fed by humans. They will survive on their own in the wild, and feeding them creates dependency. There's all kinds of science behind it. And the same thing is true with feral cats. Humans do not need to feed feral cats for their survival. They will figure it out. But the feral cat advocate feeding community would say that's not true. They will not figure it out without humans feeding them in the drainage culverts. All right, let's talk about the CC&Rs. In theory, enforcement of animal restrictions can be as straightforward as a boat in the driveway or a paint color, the traditional enforcement issues we deal with all of the time. In theory, it's just another restriction. But we do have, under federal and state fair housing laws, this idea of the assistance animal. That is an exception. So let's talk about what it means to be an assistance animal. Assistance animals are not pets. And you know this because when you are in the airport and you come upon an animal with a vest used by law enforcement, or an animal that is assisting a blind person, often the vest says, "I'm working, do not pet," because those animals are highly trained, and children are not supposed to walk up to the animal and start petting it like it's a pet, or that it's working. It's not it's a highly trained animal that's working like we're working today. Assistance animals are defined by HUD, the Federal Department of Housing and Urban Development, which is charged by statute to enforce these regulations. So the definition is assistance animals could be a trained service animal, or they could be other animals that do work, perform tasks, assist, or provide therapeutic emotional support for individuals with disabilities that affect major life activities. What's a major life activity? Well, it could be seeing, it could be walking, it could be getting through your day without a seizure. It could be a lot of things, but a major life activity is hearing. Like I said, again, getting through the day without a seizure. It's lots of things. There are two types of assistance animals. And again, thinking about these animals as pets is a mindset that's required by the law. Thinking of them as pets is going to get us into a lot of trouble. Now, an animal that is an assistance animal may be the same breed as a pet that you or I might have in our home. My wife and I have a golden doodle. My wife might love the dog a little more than I do. That may be obvious from the things that I've said so far today. But a golden doodle might be an assistance animal for someone, but a pet to us, and that's okay. A golden doodle might be highly trained to be a assistance animal to someone, but a pet to someone else. And that can be confusing to some people. For some board members, that could be confusing, that someone would come before the board and say, I have an assistance animal. It's a golden doodle. My assistance animal is highly trained to do the following things. But for the board member, the golden doodle is simply a pet. And that can be confusing. It could cause the board to act in a discriminatory way. But we have to rid our minds of this confusion, this cloudiness that makes us think that the disabled person that needs help with a major life activity is faking it or doesn't need the animal, because the animal they're using looks like my pet. So back to my point, there are two types of assistance animals. Service animals, think of a trained seeing-eye dog, for example. We know this. It's been part of our culture for many decades that a blind person might have a seeing-eye dog that would stop the blind person at the red light. Don't cross yet. That's classic. We know this. That is a service animal, a highly trained dog that assists a blind person. That's a service animal. And the second type of assistance animal is other animals that do work, perform tasks, aid or provide therapeutic emotional support for individuals with disabilities. This is where we start to break down a little bit. This is where board members become cynical and troubled and second guess whether or not the requested or needed, not necessarily requested, needed assistance animal is legitimate or not. This is where some board members start to lose cohesion a little bit, but they can't actually, because under the law, HUD says you don't get to decide for someone whether the animal is legitimate or not. And again, just because the person wants the same breed that you have as a pet doesn't mean that it's not performing a task or providing therapeutic emotional support. And here's the punchline. Housing providers are obligated to permit, as a reasonable accommodation, the use of animals that work, provide assistance, or perform tasks that benefit persons with disabilities or provide emotional support to alleviate a symptom of, that should be or effect, the symptom of effect of a disability. So that's where the law is. Housing providers are obligated to permit, as a reasonable accommodation, the use of animals that work, provide assistance, or perform tasks that benefit persons with disabilities or provide emotional support to alleviate a symptom of or effect of a disability. So here's the rubric. And sometimes this is quite challenging, and this is where lawyers need to be involved often, is that this rubric is somewhat complicated. Is the animal a dog? If yes, proceed to the next question. If it's not, the animal is not a service animal, but maybe another type of assistance animal for which a reasonable accommodation is needed. Then you proceed to question number 2. Is it readily apparent that the dog is trained to do work or perform tasks for the benefit of an individual with a disability? If yes, further inquiries are unnecessary and inappropriate because the animal is a service animal. So the challenge is, if it's a dog and it's obvious that the animal is trained to do work or perform tasks, then it's over. The dog is a service animal, and everything, it's all, you pretty much have to make the accommodation. So for example, the person's blind, you can tell they're blind, and it's a service animal for a blind person. But another thing that could happen is you could have a person in a wheelchair who has a dog that assists the person in the wheelchair. That also happens. If it's not readily apparent that the dog is trained to work or perform tasks for the benefit of an individual with a disability, then we go to the next question. This happens a good bit because sometimes we don't see the dog. Someone just says, "Hey, I have a dog." We're in a condo situation and the person says, "Hey, I have a dog and I know you have a restriction against dogs," and we don't know anything about the dog. We've never seen the dog, but it's not readily apparent that the dog is trained to do work or perform tasks for the benefit of the person with a disability because the owner and the dog did not come into the office together. We haven't seen anything. The blind person didn't come into the office with the dog. The person in a wheelchair didn't come into the office with the dog to ask about the accommodation. We don't know anything about it. So if it is readily apparent when the dog is observed guiding an individual who is blind or has low vision, or pulling a wheelchair, providing assistance with stability or balance to an individual with an observable mobility disability, then it is advisable for the housing provider to limit its inquiries to the following 2 questions. Here's what the housing provider can ask. And this has changed somewhat over the years. The most recent guidance from HUD says you can ask 2 things. Is the animal required because of a disability? And what work or task has the animal been trained to perform? And this really comes up every once in a while when someone says, "I have to have emotional support chickens." we can say, are the chickens required because of a disability? And the owner or family might say, yes, my child has anxiety. Okay, no problem, no debate. We're not going to debate whether the children have anxiety. Many people do. We're not going to get into a debate about that. We're not going to question it. They say the animal is required because of anxiety. We will never debate the answer to question one, but we do get to ask the question, what work or task have the chickens been trained to perform? And that's where I believe the nexus between the chickens and the emotional support for anxiety breaks down a bit, because I have trouble with the notion that chickens can be trained to do anything. It just makes my head hurt. I grew up the grandchild of a rancher in Montana, northeast Montana, 50 miles from Canada, 50 miles from North Dakota. And I was around a lot of farm animals growing up, visits to grandpa's. And I have trouble with this one. I have a first cousin who's a turkey farmer. And if I were to call him up and say, can the turkey be trained? A turkey, being a close second cousin of chickens. I think he'd laugh me off the phone. My cousin Jeff, I think he would laugh me off the phone. With a lot of trouble with this one. And but we have to be careful here. With this idea, we can ask two questions. Again, we're not going to debate with or argue question number one. Is the animal required because of a disability? The answer from the owner will always be yes. We're not going to ask about what is the disability. We're not going to debate the legitimacy of the disability. We're not going to get an argument about whether anxiety is a real thing. None of that. We're not going to get into any discussions about whether that's silly or dumb or anything like that. As tempting as some people will find it, because there are plenty of directors who are going to be frustrated by the answer to number one, and plenty of owners who will over disclose, or some would say overshare on number one. There's a lot they don't have to say under the law. It's actually a yes or no question. And there's no need under the law to overshare on number one. I have rheumatoid arthritis. I'll overshare a moment here. I could simply say, yes, the animal is required because of a disability. And then I could say, on number two, my golden doodle has been trained to remind me in the morning and the evening to take a couple of pills for my rheumatoid arthritis. Now, is that a true statement? No, it's actually not true. My golden doodle has not been trained to remind me to take a couple of pills once in the morning and once in the evening for my rheumatoid arthritis. Do I have to take some pills once in the morning and once in the evening for my rheumatoid arthritis? Yes, I do, but I'm actually capable of remembering it without my dog telling me. But somebody could say that. Now, would it be true in every case? Maybe, maybe not. But that would be a way for somebody to get a dog over a restriction, is the animal's required because of a disability, I don't have to say rheumatoid arthritis. I could say yes, and I could say, my dog has been trained to remind me to take medication. That would be enough. My animal's required because of a disability, and my dog has been trained to remind me to take medication. Now I'm in. You cannot ask, this is from the HUD regulation. You cannot ask about the nature or extent of the person's disability, and you cannot ask for documentation. I don't have to show you papers that I have rheumatoid arthritis. In fact, I don't even have to say the words rheumatoid arthritis. I don't have to say RA. I don't have to show you my fingers that sometimes, get a little cramped up. And I don't have to show you a documentation. In fact, I don't even know what I would show you. I don't know what I don't even have any papers. A housing provider, and let's stop for a second. Community associations are not housing providers. You're not a landlord of a huge new apartment complex here in Maricopa County or anywhere in the state. You are a community association, but even though the statute, the Fair Housing Act in Arizona's version uses the word housing provider, almost like it's referring to landlords. Long ago, the case law decided that community associations are housing providers under the statutory scheme. So although the wording in the regulations uses housing provider, kind of like a tenant walks into the leasing office, it applies. So we have that term, and you're not a housing provider. Don't get hung up on it. It does apply to the association. So it feels a little clunky and awkward. And now it's the second time I've used it in this presentation. But the association is not a housing provider in the traditional sense. But in this context, you are. The community association is a housing provider. The housing provider, at its discretion, may make the truth and accuracy of information provided during the process part, these questions made by the tenant. We're not dealing with tenants here, of course, or this housing agreement. People have to be truthful. You can't lie in questions 1 and 2. So I could say the animal's required because of a disability. And then I could say the animal's been trained to remind me to take my medication. But I have to be truthful. And as I said, if I'm trying to keep my golden doodle in a condo with a no dog rule, but I lied about it. Because as I said, my golden doodle has not been trained to remind me to take my medication. That matters, that I lied about it. So the association can make the truth and accuracy of information provided part of the regulations. So basically, if someone's going to lie about it, the association can make the truth of what somebody says part of the issues. If the answer to question 1 is yes, and work or a task is identified in response to question 2, which I did, the animal's going to remind me to take my medication. You have to grant the requested accommodation, which in my case was, let me keep my dog. The animal qualifies as a service animal. So in my hypothetical with my rheumatoid arthritis, I created a hypothetical service animal. It really was that simple. So the requested accommodation has to be granted. If the answer to either question is no or none, the animal does not qualify as a service animal under federal law, but could be a support animal or other type of assistance animal that needs to be accommodated. which is the ambiguity of the support chickens. And the animal, let's go back to the chickens. Is the animal required because of a disability? No. What work or task has the animal been trained to perform? None. But it might, it's to provide emotional support. That may be where we end up with the chickens. Because the chickens are not trained, which is the problem with the chickens. The chickens are not performing tasks, aiding or providing therapeutic emotional support for individuals with disabilities. So we're not saying no to the chickens automatically. We've got to deal with it as it comes along, but they're not trained. They're not service animals, but they might provide support. Which is what I was saying earlier. Sometimes the attorneys have to get involved in these things early because of the way people style their requests. This is interesting. There's some data. The government's pretty good at keeping the data. Disability accommodation complaints at HUD, Housing and Urban Development. 60% of the fair housing complaints filed with HUD nationally, 60% of them are animal disability accommodation complaints filed by owners. That's pretty significant. The other 40% filed by HUD are discrimination complaints in housing based on protected categories like I was discriminated against because I'm Canadian, a national origin discrimination, or I've been discriminated against because I'm Vietnamese American, or I'm African American, or some other discrimination based complaint. But 60% of all of the complaints the HUD receives are based on failure to accommodate an animal request. Seems like a lot. Navigating animal accommodations is like a phrase attributed to organized crime in Chicago in the early 20th century. Vote early and vote often. In this case, involve lawyers early. If that sounds self-serving, I don't mean it to. I had a case a number of years ago where the manager called me at the point at which the matter had gone to the Civil Rights Division of the Attorney General's office. And the manager said, well, it's dumb. It's not going to go anywhere. It's frivolous. And the first thing he said was, I told the owner that the dog was acceptable if the owner showed me that the dog has the service animal certificate. And I thought, this is going to be a problem. I thought that to myself, but I didn't say anything. And this is a real dilemma for me because I knew what you all know, that there is no such thing, that a dog is either trained or it isn't, that the dog is a C&I dog or is not a C&I dog. It's either trained to sense a oncoming seizure, or it's trained to remind me about my medicine, or it isn't. But the dog may graduate from a class and receive a graduation certificate, or it might not. But there is no legal requirement that a dog that has been trained to be a C&I dog receive a certificate that can be handed over or displayed on demand so that other people can verify this dog's legit. This dog is a CNI dog. And we can all assume that a CNI dog that's trained, that some trainer has charged thousands of dollars to train, that the dog would have some certificate of completion somewhere. It's not a bad assumption, I guess, that having paid that much money, that there is something to prove it. But the manager was wrong to demand that the owner provide a service dog certificate. And it got the association into a lot of trouble. Now, a quick parenthetical here. The dilemma for me was, knowing the manager was wrong, and I went to the board meeting, I had to tell the association, we're in a lot of trouble here. This was an incorrect position to take legally. We were not allowed to demand to see the certificate. Either the dog was a service animal or not, either it was an assistance animal or not, and demanding to see the certificate walked us into this adjudicative process with the Attorney General's office. Now the association's going to have to spend money on legal fees. Now there's an insurance claim, and if we don't change our position, we're going to lose. Now, navigating that is why I'm good at what I do. Meet with the board, say, hey, we got a hearing, let's go see what's going on, compromise, let the dog stay, navigate all of that. But the manager out of the gate took the wrong position. That's why I say we got to involve lawyers early. So the HUD notice was January 28th, 2020, which by now is 4.5 years old. If you want a copy, send us a quick email at info@carpenter.law. Happy to send that over. And, we're really just kind of dealing with situations where people want their animals and sometimes they are deceptive. And let's confront that for a moment. There are times when people have figured out that it's like modern air travel. People want to travel with their animal with them in the airplane, and sometimes they'll go onto a website and purchase a vest for the animal for $50, $75, and it's fake. It's not real, and it makes it look like the animal is trained or is a service animal and that they've got a certificate, but they don't. And so they, for $50 or $75, have a vest on the animal, but they're not really a service animal. So what ends up happening is there's deception going on, and there's no way to sift through it. And we sometimes deal with this in community associations where people, just like the manager said, I want to see a certificate. Well, people have figured out that, and there's even for-profit people who've set up websites that have said, well, for $75, I'll sell you a small, medium, or large dog vest that says service dog, and march through an airport or march through Walmart or march through IHOP or Denny's and sit with me at the restaurant, and then go to the board meeting and say, well, this is a service animal, and all I have to do is answer these 2 questions. Yes, it's required because of a disability. And what work or task has the animal been trained to perform? Well, it reminds me to take my medicine. And now they've figured out that it's all works perfectly into the rubric that HUD has created, and really was created by the Fair Housing Act. It's an act of Congress, and HUD is implementing it. So if you'd like a copy of this PowerPoint, or if you would like a copy of the January 28th, 2020 HUD notice, or of course, if you'd like help with any of these issues as they come up, feel free to contact us. If there are any questions, happy to take them in the chat. I know there have been some questions about what to do with people who have provided these questions about these animals that come in with the certificates and the vests. Yes, if an animal comes in with a vest to a board meeting, I mean a dog vest, you could still ask the two questions, and I would ask the two questions. The question is, the statute still requires a reasonable accommodation. But the two questions that are really the key to this is you still have to make a reasonable accommodation, but HUD has been pretty clear that reasonableness is based on these two questions. Is the animal required because of disability? If the answer is yes, and the animal has been trained to perform work or a task, then the accommodation pretty much has to be automatic. Reasonableness doesn't seem to enter into it too much. It's pretty much an automatic accommodation. Second bullet point up from the bottom, if it's yes, and there is work or a task identified in response to question 2, you have to grant the requested accommodation because the animal qualifies as a service animal, if otherwise reasonable. So there is still this notion of reasonableness, but it's hard to figure when it would be unreasonable. There is this idea that if the association has a food and beverage operations in a clubhouse, that having a dog in the kitchen would be unreasonable. But it's hard to imagine when a dog would be in the kitchen around the food preparation. But getting why an owner would need to be in the kitchen around the food preparation, it's hard to get there as to why an owner would need to be in the kitchen around the food preparation. But it's clear that HUD wants community associations to have a lockstep process. And I've had the question over the years many times, should the association adopt a policy regarding accommodations for assistance animals? And I kind of go both ways on this. On one hand, it would be nice to have a policy in advance. And then I think, well, but then you're kind of road mapping for people how to do it. And that's one of the challenges that we've had over the years with certain public situations, like with airlines and other places that have had trouble with animals, is when you telegraph people how to bring their animal on an airplane, it tends to increase the number of animals. When you tell people in advance exactly how to do it, then it tends to increase the total number of animals. I've also had trouble over the years, and I meant to mention this earlier, with especially with condos. My experience with animals, and again, I've only been a dog person in the last 15 years or so, is that condos that have restrictions on the weight of dogs, my experience has been that the smaller dogs tend to be louder. Small dogs bark louder in my experience, and the bigger dogs uh, tend to be lazier. At least this is my limited experience. I mean, what's my limited experience? But it seems like the weight restrictions tend to assume that the bigger dogs are more problematic. And really just hasn't been, again, I'm just one person. My limited experience is not necessarily indicative of anything. But bigger dogs, as they age, tend to be calmer and quieter. But why big dogs are problematic in condos, I've never quite understood that, at least as a matter of governance theory, why developers draft condo CC&Rs as if big, heavy dogs are bad and small dogs are okay, other than that condos tend to have smaller square footages. And if the condo is going to have a smaller square footage, small dogs would be better in a smaller square footage home, condos being smaller, and big dogs belong in bigger square footage single family homes with yards. They should have bigger animals. Maybe that's the thinking, but regardless, if that's the theory, then the manager I told the dog we needed a certificate. That owner had a bigger dog and wanted the bigger dog in the condo. And that's where that community got in a bit of trouble, is the guy had a 90-pound, whatever the dog's breed was. And the manager said, no problem, you can have the bigger dog, but I have to see the certificate. And of course, the owner didn't have one. And now I forget, it's been too many years, as to what the disability was that created the need for the bigger dog. And it's one of the things that if I were an attorney who represented, which I don't represent developers, but if I did, I would think that through with my client, the developer. Why do we do that? Why in condos do we prefer smaller dogs when the size of the condo and the bigger dog certainly can accommodate? And then we put ourselves in this fair housing position that you have to be disabled to have a bigger dog. Doesn't actually make a whole lot of sense. All right, so that's me. Happy to help if I can. And my email is a little different. The domain name is .law, which is a little different than it used to be, a .com. Scott@carpenter.law. I'm happy to help if I can. And thank you all for attending. Happy to have done this for you. And I'm sorry I didn't have my video on right at the beginning, but hopefully we got that straightened out. Hopefully you all have a great day and a good rest of the month. And as we close out June, a happy 4th. Thanks.